We are on the record in Manistee, Michigan for the video deposition of Janice McCraner in the matter of Debbra Eckhout versus the Township of Arcadia, Patricia Wilson, Greg Wisner, Janice McCraner, and Mike Cederholm. This is a matter currently pending in the Circuit Court for the County of Manistee, case number 18-16454-CZ. Today's date is Thursday, June 7, 2018, and the time is approximately 3:14 p.m. I am Susan Stiles, video operator and court reporter for Network Reporting. Counsel, if you would put your appearances on the record, I will then swear in the witness.
Frederick Stignelson from Jesse L. Williams Law and Advocacy Center on behalf of the plaintiff.
Brad Word appearing on behalf of the defendants.
Ms. McCraner, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the whole truth?
I do.
Ma'am, would you please state your full name for the record?
Janice Marie McCraner,
Could you spell your last name?
MC, capital C-R-A-N, as in Nancy, E-R.
And Ms. McCraner, what is your role with the Township of Arcadia?
I'm the Township Supervisor appointed to fulfill a term of the supervisor who resigned.
And how long have you held that position?
Since April of 2017.
And what training have you undergone as a Township Supervisor?
I was the former supervisor from 2000 to 2004, and I took the MTA training course for supervisors and accomplished that. I also have my citizen planner from Michigan State University, and I was a county commissioner for 4 years and also took the commissioner training and successfully completed that.
And just for clarification, when you said you were previously the supervisor, that was for the Township of Arcadia?
Yes, I was elected.
And when you were a commissioner, that was in the County of Manistee?
Correct, elected.
Did you receive any training with regards to the Freedom of Information Act?
There was a course that I took when the supervisor MTA course was put forth, and it was just to familiarize yourself so you understood what it was.
And that was when you were serving as the elected supervisor?
Correct.
Okay.
Mm-hmm. And I have gone on the MTA website and viewed the information that they do have on that. That's free for all elected officials.
And it occurs to me, I just jumped into this, you've sat through several depositions, or 2 depositions today. Mm-hmm. Have you ever been deposed before?
Never.
Okay. Do you feel, you heard me reviewing sort of the details with the other deponents. Do you want me to go through those with you, or about how to conduct the deposition?
I'm pretty comfortable.
Okay.
Yeah.
And counsel, you?
Yeah, let's proceed.
Okay.
Good.
And when you obtain training like that, is that paid for at the expense of whatever the entity that you are serving in?
Well, when I took the supervisor training, it wasn't. I was fortunate enough to win that position at the primary, and I knew I had no competition for the November election. And so I took it upon myself to go to the MTA headquarters in Lansing and take that training, because I had never held an elected position before, and I felt I needed to have a little bit of a head start before I started taking office in November.
Okay, and but as in general, with the sort of the practice of your township where you work now, is training expected and encouraged?
Oh yes, most definitely.
For the board members, or?
All board members, yes, And I get every couple of days, sometimes every day, what's called a supervisor alert, and they give you information questions, things that you need to be aware of from MTA.
And even though, so your situation with regards to the training was a little unique, but if for example, you got an alert about a certain training that would be applicable for the clerk or for trustees in general, you would share that information with the board?
Yes. Mm-hmm.
And then if they did attend that, then that would be, a reimbursable expense.
Absolutely.
And since taking office this time around, have you had any additional training?
I went to a grant writing class in Cadillac, and just some online things that I've gone through and read to further educate myself. I have not traveled per se. Okay.
Do you know generally what the duties of a FOIA coordinator are?
Yes.
And in your understanding, what are those duties?
That when you receive a FOIA request, it is the clerk, who is our designated FOIA recorder, or person coordinator, that they are responsible for moving forward with that, and ask other board members if there's things that we can supply to coordinate with that request. And so far, Patty has, our clerk right now and our FOIA coordinator, has always informed us when she receives one.
So when she receives a FOIA request, she would inform you and the other members of the board?
Usually, I can only speak for myself, but I would assume so.
Do you recall, and I think you already said it, but you started in April of 2017, right? I'm handing you what's been marked as Deposition Exhibit 1 from Patty Wilson's deposition. It's a September 22nd FOIA request by the Debbra Eckhout, the treasurer, as an individual.
I'm familiar with this.
With that request?
Yes.
So you were contacted by the FOIA coordinator at that time?
Yes.
What efforts did you make to find documents that were responsive to that request?
At that time, Ms. Wilson said that she was going to be contacting the attorney because we were all concerned about what we should or should not release. And under her advice, after she had spoken with the attorney, it was clear that the reply would be that it would not be able to be put forth in its entirety.
Okay, so it's fair to say that essentially you were kind of waiting, you were in a holding pattern until you received the guidance, and you don't need to tell me exactly what but the clerk informed you she was going to contact the attorney.
Correct.
And then you sort of waited before you took any action with regards to this.
Correct.
So you did not go through your emails and dig up emails and say, what about this email, what about this email, how does that work?
I did not.
Okay. And do you know whether an actual denial was issued in answer to that request?
She did say that there was a denial.
And do you know whether that denial identified with any sort of particularity the documents that were being withheld?
I just remember seeing the denial. I don't remember the exact verbiage that was used, but I do remember that there was a denial.
I'm handing you what's been marked as Deposition Exhibit 3 in the deposition of Patricia Wilson. Do you recognize that document? That's a November.
I do.
Okay, I'm sorry. So that's a November 10th Freedom of Information Act request by Debbra Eckhout.
Correct.
So again, similar procedure. The clerk contacts you,
Yes.
notifies you of the request, and then
I wait to hear from her if there's documents she needs me to go through or look through what I have. And the response was that it was broad, and at this time there was not going to be a need for me to do anything with that.
So again, with regards to the November 10th, 2017 Freedom of Information Act request, you did not make any efforts to identify any records in your possession that would be responsive.
Correct.
And you did not, since you didn't identify them or make any effort to, you would not have disclosed those to the coordinator.
Correct.
And have you seen this document? This is Defendant's Exhibit 4. It's a November 28th, 2017 email.
Yes.
It's been discussed at length today.
And I have seen this.
And knowing what you know, obviously you've sat through some depositions today and you've had your training and with regards to the act. Would you agree with me when I say that this denial, this document, is not compliant with the Freedom of Information Act?
I can't say that I agree with you. I have heard the rationale for why it was not given to the requestee, and I was comfortable at the time with that.
Do you agree that this email does not include any sort of language about how a person an aggrieved party from this decision could seek relief?
I do.
And do you agree that this email does not identify with any particularity the specific documents that are being withheld?
Correct.
And do you agree that this email does not provide those documents that would be identified to be non-exempt.
As presented, yes.
And in fact, you did acknowledge in your response, excuse me, I believe it is, you helped prepare with Mr. Weirda the responses to to the discovery request from our office.
I did.
And you did, so you responded both to a request for admissions as well as interrogatories. You recall that?
Correct.
And in request for admission number 10, I think that's the interrogatory.
Oh, I'm looking at the wrong thing. Request for admissions.
Number 10,
You'd have to read
the
that.
question was, admit that some of the records which were relevant or responsive to plaintiff's first FOIA request were non-exempt from disclosure pursuant to the Act. This was being the first FOIA request, the November 10th request, and this being the response, Exhibit 4. You stated that you admit that some of those records that were relevant or responsive to plaintiff's first FOIA were non-exempt from disclosure pursuant to the Act.
Correct.
And you agree with that today?
Yes.
So, as far as that goes, do you agree that not providing the non-exempt records would be a violation of the Freedom of Information Act?
As of today, my understanding, yes. At the time, I was following our attorney's advice, and today, with what I know now, it could possibly be misconstrued as that, yes.
Does he? Obviously, this litigation is ongoing, and as I stated before, costly, and as the supervisor of the township, does that cause you some concern that based on an attorney's advice, the township was subjected to a lawsuit?
Of course it does. I'm a fiduciary agent of the township, and it does concern me. And did you help prepare the documents that were submitted as the responsive to the interrogatories? This huge stack that you see me waving around. I'll pull it back up.
The supplemental document response.
Yes, I had gone through. You're talking about me personally going through my emails
Yes.
and getting. Yes, I did.
Yes, and do you recall how much time you spent doing that?
It was several hours. I don't remember the exact time.
Based on what you've heard today, would you agree that those several hours, that would have been something that should have been undergone in response to the first request?
Knowing what I do today, yes.
Okay. Do you recognize, after sitting through the depositions today, that in fact that this is... Actually, let me go back. There's obviously been some tensions on the board, and I'm curious to know whether you, as a supervisor, is there anyone in particular that you blame for this lawsuit? Do you blame the treasurer for this lawsuit?
I blame the lack of cooperation. I'm a consensus builder, and when I came on as supervisor, I felt it was very important for us to start working together as a board, and that very quickly became apparently clear that that wasn't going to happen. And we have 4 board members who work very, very well together, the clerk, the supervisor, and the 2 trustees. So we do have some contention, and there's some issues with our treasurer.
And so, but so knowing what you know now, knowing that that at least the alleged concerns in the complaint with regards to the Freedom of Information Act counts, that those appear to be, from your own statements, legitimate concerns regarding how these requests were responded to. Do you acknowledge that it is a legitimate lawsuit in that regard?
Objection to the form and foundation. You can answer whether it's a legitimate lawsuit.
I can't speak to the legitimate lawsuit, but what I can say, hindsight is 2020, and none of us are perfect, and at the time we felt we were doing what was legally right.
Would you also agree that, like you said, that the cooperation having been an issue, that the lack of cooperation factored into the deficiencies of this response?
They certainly could have, yes.
So perhaps if everybody, no matter which side of any of these issues what people were on, so better communication with the township, between the township board members, could have perhaps vitiated, if you're familiar with that word, or made not necessary, one, a Freedom of Information Act request, but two, a lawsuit under the Freedom of Information
I think
Act.
it's important as an elected official to be professional, and there will be areas that you'll agree and disagree with your other fellow elected officials. And I think you have to be able to put those aside and move forward with each issue as it presents itself. And unfortunately, in some of these issues, it has not happened.
And would you agree that whether you think the majority is on one side of whatever, that is a fair statement on behalf of pretty much all the parties involved?
I'm sorry. You're asking her to speak for everybody else involved?
Yeah.
Is that the question?
Well, she's speaking about the actions of individuals. She's saying that this is because of some of these disagreements and the cooperation. I'm just saying,
I'm
said that
speaking about myself.
Okay.
As a board member, I'm a consensus builder, and I feel very strongly that as issues present themselves, each board member, as a professional representing a constituency, it's important for them to be able to put an issue aside and move forward. That has not happened in this case, and I'm only speaking for myself.
Okay. So your impression is that both the Freedom of Information Act request and also the response to that request are essentially a result of that lack of cooperation.
Yes.
Okay. Now, when you send an email to the township attorney, do you believe that there is a privilege, and I'm talking about the attorney-client privilege, with regards to that communication from you to the township attorney and from the township attorney back to you, that doesn't extend to, for example, the clerk?
Sometimes.
Object to the extent it calls for a legal conclusion, but you can answer.
Sometimes.
And if the treasurer sent an email to the township attorney, you would believe that email to him could be protected from you?
Can I have that same
Yeah.
ongoing objection? Thank you.
Sometimes.
Oh, okay. And but you agree that the township attorney works for the township as a whole, not for any one of you individually?
Correct.
Okay. Now, you've heard some discussions today about some of these requests. Now, why not give all of the documents requested in Deposition Exhibit 3 by the Debbra Eckhout, the individual, but why not give those to her in her official capacity as the treasurer?
As I said, at the time, we thought we were doing what was correct following the advice of our attorney.
And that goes to, as well, there was an email that was sent to you where she did request essentially the same thing. I believe, I have all these, sorry. Actually, right here. Exhibit number 5. Do you recognize that email?
I do.
And you recall that being sent to you and other members of the board?
I do.
And is it fair to say that those documents were not provided to the treasurer in response to that email?
And some of those documents she had in her possession. They were copies that were made in board packets and so on and so forth, and this was very broad, and so it wasn't specific as to what communications. It was all communications.
Right. And you don't believe that she would be entitled to those?
To what?
All communications?
Well, I think that when I read this, I felt it was very broad, and that I was not going to be sending communications that, say, a trustee sent to me asking me a personal question about something. If it was board related, most of those things were going to the treasurer.
Would you agree that pretty much everything to do with the marina fraud investigation was board related?
I wasn't involved. The marina investigation had been closed by the time I became the supervisor. That was closed as of February 10th.
Of 2017?
Yes.
So when your FOIA coordinator invoked the ongoing law enforcement investigation exemption in in December of 2017, that would have been misguided because with regards to communications about the marina fraud, that would have been misguided because, as you just stated, that had been closed since before you even
The letter
came
that
on.
we received with the FOIA request from our attorney, when we finally received the unredacted police report, Ms. Eckhout had been sent a letter saying that the investigation was closed, and if the trooper felt at that time, I'm sure you have a copy of that police report, and if the trooper felt at that time there were reasons for him to further any investigation, that was up to him to send it to the according authorities.
Okay, so we can agree though that in November of 2017, as far as you're concerned, as the supervisor, that investigation was closed, the marina fraud investigation.
Correct.
Okay. Do you feel, without talking about the specific advice, do you feel that with regards to responding to this initial, this request on November 10th, 2017, that do you know whether or not the clerk complied fully with the attorney's advice?
At the time,
I'll just object on
Okay.
foundation grounds in terms of how she would know what the clerk did, but you can answer if you can.
At the time, I was relying on the information from the attorney and the clerk.
And your understanding is that the clerk just did whatever the attorney essentially told her to do?
Same objection,
Yeah.
foundation. You can answer if you know.
I wasn't privy to those conversations,
Okay.
so I'm not exactly sure exactly what was said to her or him.
Okay, I'm
Vice
just curious,
versa.
because in your response to the interrogatories on several requests, your answer, for example, to interrogatory number 5, you stated, we consulted with our attorney regarding the scope of the attorney-client privilege and then withheld the documents which we understood to be protected by the attorney-client privilege. So
We as the board.
we as the board. So did you as the board vote to how to respond?
To my recollection, there was no vote, but the clerk communicated with each elected official.
So the clerk communicated with each elected official, and then jointly you made a decision on how to respond?
The FOIA coordinator made that decision after conferring with us.
And each person would then give their input to the FOIA coordinator, and then she would make the decision?
I'm assuming so. I can only speak to what she shared with me.
Okay, and so, but your understanding is that the FOIA coordinator communicated with you?
And
She
shared,
communicated with I'm sorry, Mike Cederholm?
I'm assuming so, yes.
And then communicated with Greg Wisner?
I'm assuming so.
And then probably did not communicate with the treasurer?
I have no knowledge of that.
Okay,
And
am I
as I
missing- am I
said, I'm
missing someone?
assuming.
No, so
There's 5 board
Yeah.
members and myself, the clerk, 2 trustees, Mr. Wisner and Mr. Cederholm, and the treasurer,
Okay.
Debbie Eckhout.
So
Thank
when you say we consulted, so the FOIA coordinator gets the advice from the attorney, and then reaches out to, in this case, the 3 other members of the board, not with Debbie Eckhout because she made the request.
Let me just put an
Yeah.
objection again. Her answer to each one of those other than herself was, I assume. So if you're asking her again, I mean, she's already stated that it's a guess, it's an assumption that she's making in terms of communications with others. Now, I think you're asking her the same question again.
Well, I think the first answer was that she said that we decided as a board because the FOIA coordinator communicated with all of us and we made the determination. And so that's why I'm trying to
You
flush out.
specifically asked her.
I did that after
the-
she made that first statement about we as a board made the determination. I said, what do you mean we as a board?
Okay. Let me just, then I'll get out of your way and just put the objection on that I object on foundation grounds. to things that she doesn't know about, you asking her about conversations or meetings that she was not a part of. And then I'll get out of your way and let you do what you're going to do.
You did say that we as a board made this decision, right?
And my assumption, as I said, I was not privy to all the conversations, but we, meaning the board, moved forward with that. But I was not privy to every conversation the clerk may have had with each individual board member, or she never replied or said to me, I've talked or spoken with this one, and this one. I can only speak to what she shared with me.
So how does the board make a decision if a quorum of the board is not around to make that decision?
Because we would have to hold a special meeting if there's going to be a quorum of the board. You can't have a quorum of the board and discuss business without a special meeting. A special meeting was never called.
Well, your assumptions about the communications between the FOIA coordinator and all the members of the board, excepting Ms. Eckhout, would be a meeting of the quorum of the board, which would not have been noticed. So my question is, how does the board make a decision without having a meeting or without having a quorum deliberate towards that decision?
Just going to object again on form grounds. I think she already said that the clerk made the decision on the FOIA response, but you can answer again.
But hold on, that's not what she said. She said that we, the
record
board,
will say what the record will say specifically what she said. She actually said specifically those words. I think I don't really want to stand here and argue with you, but I think she specifically said that the clerk, the FOIA coordinator, is one response. But again, we've got a record. It will be here.
We do.
Yep. So I don't want to argue with you.
So the board made the decision. That was your testimony.
What decision?
The board made the decision on how to respond to this FOIA request.
As I said, I was not privy to the conversations that the clerk had with each individual board member. I am supposing, I do not know for sure. I can only speak to what I spoke to her about.
And you're assuming that she spoke to you and then all the other board members?
I can't say for sure. I was not privy to those conversations.
So when you say we consulted our attorney regarding the scope of the attorney-client privilege and then withheld the documents which we understood to be protected by attorney-client privilege, is that, are you attempting to mislead me with this answer, or is that not, because when you say we and then you define we as the township board, I'm just trying to clarify who is actually consulting with the attorney, who is making the determination?
Objection, form, and foundation. And just a reminder that this is the village's discovery responses. You can answer.
I'm saying that I spoke with the clerk. She shared the information that she received from the attorney, and I agreed with that response.
So when if you're looking at, and you are the one that signed these under oath, right?
Correct.
Okay. So there's a difference when you refer in your answer to number 5, which we've now discussed somewhat at length. When you say we, would you agree that there's a difference between who the we is that you're referring to in this answer and, for example, your answer to number 6, when you say the FOIA coordinator in assistance of the township attorney is the person who actually prepared the denial?
What is the question? I'm sorry. Can you explain?
I know, but
Objection form. I mean, what is the question?
you know, you were getting after me earlier for being argumentative. Now you're getting argumentative. I don't know if it's because you're tired, but I'm asking. She says we. She defines it as the township board. Then I go into what we means. And now now it's being pinned back on the FOIA coordinator. But so my question is,
what would you like the village to what pronoun are you supposed to use for the village if you don't use we? Do you use I? Do you use you? When you're referring to the village, since these are the village's responses, what would be the appropriate pronoun if it's not we? Is that what you want to argue about? Is the
question
pronoun
is
used
there a
for the
difference
village?
between the pronoun we and the FOIA coordinator in conjunction with the township attorney? Is there a difference between?
When I answered this question, I was talking about myself and the FOIA coordinator that I spoke with. I wasn't, as I'm reading this question again, it's been months since I've looked at this. We consulted with our attorney, and it says right here, the FOIA coordinator with the assistance of the township attorney. That is more than one person, so we would constitute myself, she coordinated with the township attorney, and I was consulted by the coordinator.
But you actually, you never personally consulted with the township attorney.
No, but I consulted with the FOIA coordinator, and I would say that that's a we, because more than one constitutes we, correct?
Well, it would be the FOIA coordinator. Wouldn't you agree that a more accurate statement would be the FOIA coordinator consulted with the township attorney and then consulted with me and consulted with the supervisor? It's just not very clear, so.
Have I cleared it up for you now?
No, you have not. So I'm
Okay.
asking you again.
I'll let you know
we?
one more time. We means more than one. When I work with my students that I work with, we use pronouns. And we means more than one. And one would have been me on my own making that decision. I did not. The FOIA coordinator consulted with me, who had already consulted with the township attorney. And we means me and the FOIA coordinator. We consulted, that we talked, and after she consulted with the attorney, that was the decision that was made.
All right.
I did not personally consult the attorney.
So when you testified earlier that we was the township board, that was not true. What you mean was we was just me, you, and the FOIA coordinator.
Objection. And I will instruct her not to answer because it's argumentative. Again, the record will say what it's going to say, but you making misrepresentations about the record is not how we're going to proceed at 3:45 in the afternoon.
Well, first of all, she said that, and I don't know if we can go back and hear it, but I don't know why. I don't even see how that's argumentative. I'm just asking, is the we, when she said earlier that the we was the township board, that's when we went down, hold that rabbit hole. Now she's saying we is just the FOIA coordinator and the township supervisor. So the question is, when you previously said we was the township, referring to the township board, that was not correct.
I wasn't looking at the question, and when I said we, when you asked me the question about we as a board, and I was talking about we as a board, that particular question deals with just the FOIA coordinator and her advice.
Okay. So do you agree now that at the time that denial, the November 28, 2017 denial was issued, that there were public documents in your possession that would have been responsive to that request?
Knowing what we know now, yes.
Well, without the caveat, do you agree that at the time that that denial was issued, that you had in your possession public records which were responsive to that FOIA request?
Apparently so.
Okay. And you agree that that is a violation of the Freedom of Information Act?
Apparently so.
Now let's talk about Ms. Eckhout's second Freedom of Information Act request, which is Deposition Exhibit 6. Was that shared with you? This date is December 14, 2017. Again, that is a copy. That is not the request that was provided to you.
I remember seeing this request.
And so again, same procedure. The FOIA coordinator contacts you
Correct?
and says, "Hey, I got this," and then asks you to hold off, or essentially the idea is that you hold off until she's spoken with the township attorney.
Correct?
Now, what efforts did you make to obtain documents that would be responsive to that FOIA request?
When the clerk corresponded with me again, she explained the attorney's advice, and I suggested that we go with the attorney advice as well.
So again, and let me dig it out. Exhibit 14, December 21st, 2017. That is the denial, essentially, at least denial in part of the plaintiff's second FOIA request. Have you seen that before?
Yes, I have.
Okay, so without telling me what the advice was, your understanding is that that denial is fully is based on the attorney's advice
Correct.
in whole. Like it is 100% everything that he would have told the FOIA coordinator to do.
I wasn't privy to the conversation, but I'm assuming so.
Well, you told me that the FOIA coordinator told you what the attorney said, right?
Well, not verbatim. She just explained to me that pretty much what it was written in here, that that's what would be done.
And again, at that point, she didn't tell you to look for any documents.
No.
She didn't tell you to provide itemization of the documents or identify the documents that you were going to withhold.
No, because I remember seeing in here that there needed to be clarification.
Clarification as to just...
Please clarify what you are asking for in this request. Emails between whom and date and range, please.
It sounded like you were talking about working with students. So what, if you're going to read a sentence, you got to read the whole sentence. So what...
Oh, number 10.
Okay, so that's...
Please clarify what you are asking for in this request. Emails between whom, ? And date range, please.
So is it fair to say that that request for clarification only applies to number 10, right?
I'm assuming so.
Yeah, and that denial denies 1 through 22, excluding number 10 and number 27, right?
And yes, and then on number 27 says, I will have to ask for a 10-day extension.
Okay, so I never realized 1 through 22, excluding number 27. That doesn't make any sense. But let me ask you this. So do you agree that there are public documents in your possession, or there were at the time that this denial was issued, that were responsive to this extensive Freedom of Information Act request, Exhibit 6, that you did not provide to the requester?
Yes.
And some of those documents would not have been covered by any privilege. Do you agree with that?
Knowing what I know now, yes.
And you agree that there was no effort made to list in any sort of matter or provide any affidavit of exemptions or anything in response to that request?
Correct.
So, based on your testimony today, it sounds like the FOIA coordinator acted in accordance with the advice of the attorney.
Correct.
And knowing what you know now, the attorney's advice was incorrect.
In some parts, yes.
Okay. Are you planning to take any action against the township attorney for subjecting the township to this lawsuit?
That would be a board decision.
Yeah, objection to the form of the question.
Now, the cooperation issue that you've discussed, you've stated publicly that you believe the treasurer is a criminal.
No, I have not.
You have not requested criminal investigation of the treasurer at public meetings?
Yes, we did. The board decided to move forward with the criminal investigation.
And so you requested the township attorney to investigate the treasurer in regards to various issues that you were having?
No, we asked him to make a report of any infractions there could have possibly occurred.
You engaged Carl Heiser as part of your investigation of the treasurer?
The township board did.
And currently, you're having a dispute about payment with Carl Heiser, is that correct?
We still owe some money for travel and bed and breakfast expenses, travel expenses.
And you yourself have written a letter to him saying that part of the reason that you didn't want to pay the rest of the bill was because you believe he was colluding with the treasurer, is that correct?
No, I did not write a letter.
You did not write such a letter?
I did not write a letter.
Did you present a list of questions to Carl Heiser?
I had a telephone conversation with him, yes.
And is that fair to say that you made that statement to him, that part of the reason you weren't paying him was because you didn't?
No, I did not make that statement to him. I asked him a question about if there had been any collusion. I did not make a statement or accuse him.
And that's because you weren't, essentially you weren't happy with the findings that he had, right?
No.
You weren't happy with them.
I'm answering no to your question. You asked me if I was not happy, and I said no.
Okay, so the answer is that you were not happy with his findings.
If you ask me a question, I'll answer the question. That wasn't a question, that was a statement. What's the question?
Well, a statement is also a question, as your attorney could probably advise you. So when I say, and you were not happy with Carl Heiser's findings, that's a question.
Can we just ask, were you happy with Carl Heiser's findings? I mean, if it seems to be a disconnect there between the two of you.
Isn't it true that you were not happy with Carl Heiser's findings?
That is not correct.
Okay, so you are happy with his findings.
I'm not saying we were completely satisfied. There was some dissatisfaction and some things were not accomplished.
Immediately after Carl Heiser gave his report to you at a public meeting, you voted to engage and launch a criminal investigation of the treasurer.
The board did.
Well, you made a statement, right? You made a motion.
No, I do not make motions. I said I would entertain a motion.
Okay. So, okay. So even though I was at the meeting, maybe I'm misremembering. Let me ask you this. Have you been reimbursed for your expenses in 2017?
Yes.
Have you been reimbursed for mileage?
Yes.
Have you been reimbursed for other expenses that would have been incurred in your duties?
Correct.
And you're aware that the treasurer has not, other than April 2018, that the treasurer has not been reimbursed for any of her requested expenses?
Because documentation was not provided. Correct documentation. That's my understanding.
So your understanding is that if she did provide the correct documentation, that being the Google Maps, that you would vote to reimburse her for those expenses?
Objection, form, and foundation. You can answer.
I have no answer.
Are you refusing to answer the question?
As I said, if there was proper documentation, there would be reimbursement, just like all the other board members do.
So that's the only thing that's missing is just proper documentation.
Correct.
So when she brings that next week or tomorrow with proper documentation, you don't see any reason why she shouldn't get reimbursed.
If there's policy in place to reimburse what she's asking for, absolutely.
Well, isn't it true that the practice since you've been in office had been to reimburse the treasurer for her miles?
Yes, and then it was brought to our attention by the clerk that is not a practice within our policy, so that has to be looked at, and it'll be looked at our June board meeting.
And so your position is that you're going to retroactively apply that, and essentially, even though she had been working under the assumption and the continuing practice that she would be reimbursed for her miles, you're just going to not reimburse her for an entire year because you now have found a caveat?
That will be a board decision. That will be taken up at the board meeting.
And with the toxicity of the board towards the treasurer and your own personal opinions of the treasurer, isn't it fair to say that likely will not turn out well for the treasurer?
I can't predict the future.
No. Are you stating that clearly with regards to any of her travel expenses, with regards to her training and her per diem, those would all be reimbursable expenses, right?
Correct. And
in that case, really there's not any necessary documentation other than the documentation of the hotel or the actual event that was attended.
Correct.
And as a treasurer, she both has duties as a treasurer but also as a board member, right?
Correct.
So for educating herself, she could educate herself with regards to her duties as a treasurer, correct?
Mm-hmm.
And her duties as a board member generally, correct?
Correct.
How many times do you recall the treasurer requesting reimbursement at public meetings where you and other members have refused to bring it to a vote?
I do not have any idea.
Has it happened at least once?
Yes.
Has it happened twice?
Yes.
Okay. Now, do you agree that you have a duty as a township to at least review and audit, review or audit, you can use that term however you want, the expenses that are being requested and then make a determination as to whether those expenses are reasonable?
The board would do that.
Objection. Foundation calls for a legal conclusion. If you're going to go down a whole list of them, again, if I could just have a standing objection, then I won't have to object to every question.
That's fine.
Yep. So he's asking you, I think, about the law, right?
I can't state the law. I can only state that as long as there's proper documentation, those reimbursements are usually handled in the correct way.
So let me ask you this: if the treasurer made a motion to be reimbursed, would she would just say, I have a reimbursement, I would like to be reimbursed for these 3 documents? Would there be further discussion before it's brought to a vote, or would there have to be a vote just to bring it to a discussion?
Of course, it depends on what the reimbursement is. So not knowing the specifics, I can't answer that question.
Well, don't you agree that it's sort of, let's call it suspicious, that the treasurer, the person who has been having the most issues with the township board, as it currently is made up, is the person who is being reimbursed for the least of her expenses?
I guess that could be your opinion, yes.
Well, my opinion is that you and the other board members are systematically undermining the treasurer and choosing not to reimburse her because you don't like her.
Don't answer.
And that's a question. That's a question.
You don't have to answer that question. That is argumentative, it's badgering of the witness, and it's simply an attempt for you to badger the witness to put on a dog and pony show for your client. And if you want to take it to the judge, we should go there right now. We've got a videotape recording of it. You can ask the judge if he thinks that question is badgering.
Well, I'm sure we'll be in front of him soon enough. My question is it not because, don't you find it, or I guess my question is, isn't it because that you have professional and personal issues with the treasurer that she has not been reimbursed since April of 2017?
I do not have any professional or personal issues against the treasurer.
So right now you have no professional issues with the treasurer?
My concern is that the treasurer, as an elected official, needs to do what is obligated and statutory. And if those things are not being accomplished, the board has a right to be able to move forward in a way that is necessary.
So is that not a professional issue with her?
That's her professionalism, not mine.
You don't believe this treasurer is complying with some of her duties, right?
Correct.
And that has infected pretty much all communications, pretty much anything that the township board is trying to do or that you're trying to do with regards to the treasurer, that's been affected by that opinion and by your perception of how she's not performing her job, right?
Her actions, correct.
Yeah. And that includes how the FOIA was dealt with?
Separate issue.
You testified earlier that the way that the FOIA was dealt with was because of the lack of cooperation on the board. So
I'm sorry, when you're finished.
That
Are
was
you
not your
finished?
testimony?
Objection, Foreman Foundation. You can answer again.
That was not my statement, that it was because of issues, professional issues with the board. These were not dealt with because we were going under the advice of our attorney at the time.
So insofar as the record reflects that you testified otherwise previously, that would, my mischaracterization is incorrect.
I'm sorry. Can you repeat that one?
Yeah.
So what you're telling me is that I misremembered when you said that the lack of cooperation between the board members was the reason for, and I believe we were actually talking about the first denial.
I'll just object on Foreman Foundation grounds.
Oh, excuse me.
It's
No.
okay. I'm sorry, so you don't remember, or I'm wrong?
What's your question?
My question is, you testified earlier that the way that these were handled could have been avoided if there wasn't such a breakdown of communications. And if I'm misremembering, then just tell me, or if you don't remember, then tell me you don't remember. That's all I'm asking.
I don't remember saying
Okay.
it was a miscommunication.
Okay. And you don't remember saying that it was due to the lack of communication between the board members?
Because of the FOIA requests?
Ma'am, it's just a question.
She's asking for a clarification of the
Yeah.
question.
The question is, again, the question is, you testified earlier, and if I'm wrong, tell me I'm wrong, and then we can deal with it later. But
Correct.
you stated earlier that the way that these were handled, essentially what you were saying was that it was regrettable because it could have been avoided. Because if there had been better cooperation
If we'd have
between the board.
known then what our attorney advice was, and that's what we went on. It wasn't because there was poor cooperation between the board members.
Okay, we're going to move on. Do you agree the treasurer should use QuickBooks?
Correct.
Do you agree that she requested reimbursement for QuickBooks?
Yes.
And you refused to reimburse her?
The board, the motion didn't go through because we already have a two-party system QuickBooks, and the township provides the laptop for the treasurer to use for the QuickBooks that we already have purchased. And she has her own password and administration number.
Okay. And that's your under oath testimony today?
Mm-hmm.
All right.
All
And
of this testimony is her under oath testimony for today.
Just making sure she remembers.
Yeah,
So-
that's also badgering.
So, what about, let's talk about the fire safe. Were you on the board when the fire safe was purchased?
Yes.
And you voted to authorize the payment of $600 for the fire safe?
Was never voted on. A receipt was, I'll wait for your question.
Where is that thing? Your testimony is that the fire safe was never voted on?
To the best of my knowledge, I think there was a motion brought forth. It might have been seconded. I don't remember exactly, but I think that payment was denied because there was not a proper receipt.
And your counsel's doing a great job of protecting you. I'm not trying to be badgering. I'm just trying to clear up because now you just gave me two different answers again. So my first question was, do you recall that there was a vote for the treasurer to purchase the safe for a specific amount? And you said,
I
no,
don't
there was
think
not.
there was I do not think there was a vote on that, but I'm correcting myself and saying if there was a vote, because that was months ago, if there was a vote, then it probably was denied because of the receipt not being
Those damn stickers.
made available.
If I can see my stickers here, I'm going to hand you what's been marked as Deposition Exhibit 17 for the deposition of Janice McCraner. Those are some, oh, I'm sorry. Those are some minutes. Do you recognize those minutes?
So as I said in my second statement, and I correct myself, it was in the minutes. The motion was made by Eckhout to approve the safe for $600. Cedar Home seconded, and it was not passed. So that was not reimbursed.
So, I'm going to read this out to you, and you tell me if you just misread it or if you're trying
Okay.
to mischaracterize what it says on the page here.
All right.
Fireproof file safe. Motion by Eckhout to purchase safe for $600. Cedar Home second. Roll call. Aye. G. Wisner. Eckhout. Cedar Home. McCraner. Nay. P. Wisner. So is that, you just said it wasn't passed. Isn't that passed?
So there were 2 votes aye and 2 votes nay. So it wasn't passed. Correct?
I thought the nay vote was just P. Wisner and all the others were ayes.
Treasurer, okay, let me read this. Aye, Wisner, Cedar Home, McCrae. You're right, I misread it, I'm sorry. I was reading the A's as no's, so I misread that. I'm sorry about
Okay,
that.
so you agree that you misread it, but you also agree that it was approved.
There was a vote to approve that, yes.
And the specific purchase for $600 was also authorized.
Correct.
Okay.
And that was in June,
Of 2017.
correct. And I apologize, that was my misreading that.
Sorry, there's a lot of stuff we're going over, so it's confusing. When you prepared the response to the interrogatories, how can you describe for me how? I mean, I think you said that. So you submitted some records that were requested of you. Is that correct?
Correct.
And that was requested by the township attorney or your current counsel.
I don't want. I'm going to object to any communications.
Okay,
by
I don't
me to
want the
her.
specific. I'm sorry.
And I'm concerned. Are you mixing responding to the FOIA request with responding to discovery? I don't.
Well, and that's something we're going to be dealing with because I disagree that it's a supplemental FOIA response when there's already a lawsuit.
I know you do.
And
Yep, I
so
know you
my
do.
question is, for example, when I requested that you describe, I'm going to say, for example, number 3, which is describe and identify with particularity each document that the Township of Arcadia, its supervisor or FOIA coordinator have withheld from plaintiff when responding to plaintiff's first FOIA request. Please make clear to identify the date each document was created, the length of each document, and the subject matter and nature, general contents of the document. Do you agree that you did not do that in response to my request for these interrogatories?
I'm just going to object on form and foundation grounds. Again, I can address it with you, but apparently you want some testimony from her. But
And then you were provided with the affidavits with the redactions, correct?
Right, but those are redactions that are, can we agree that those are redactions of what is being withheld from the supplemental response? Is that fair to say?
yes,
Yes.
not to testify, but
Yes.
to speed things
Well, I
up.
was going to ask you what the supplemental was, so yes.
Is that fair to say?
Oh,
So it's
yes.
fair to say that in response to this question, you did not actually do what I had requested, which is identify the documents that were withheld from the first one, because there's 2 FOIA requests. You submitted a supplemental response that doesn't really say which one it's responsive to. And so what I'm trying to figure out is what was withheld from the first, in the first denial, and that's what that question is requested. So
Let me clear it up for you. The supplemental response was a supplemental response to both. And so if, to the extent you meant question 3 to be when you first responded, we could have said, please see the gigantic pile of documents and the affidavit.
that's what you said.
Well, I think we just said, please see the affidavit, actually, because just because it's a supplemental response doesn't mean it's not a response. I mean, where there's a miscommunication, I think, between you and me is you're saying when you made your first response to the first FOIA request. And I read your question as when you responded to plaintiff's first FOIA request, which was both the first response and the supplemental response. And so you can do a question thing with her on that, but when the answer was made, that's why it was made that way.
I feel like you're trying to pull some kind of weird switcheroo on me. This is a discovery request. The FOIA, the violation already occurred. I'm trying to figure out how many documents were withheld at that time. in response to the-
There's a stack this big, and then there's an affidavit on the with redactions.
So
I mean, we're not trying to hide anything. We're trying to be as transparent as possible. We gave you a stack of 801 documents that were not produced the first time. There was not a single document produced the first time.
But does that describe and identify the documents that were withheld from the first FOIA request? That's not describing and identifying. You want
the no, I don't at all. You want the first one separated from the second one? These are all of the documents. If you want them described, look at them, and then if you want to know what's actually still withheld, what you still haven't seen, look at the affidavit that we provided you. There's nothing attempting to be misleading about it.
It is. You're trying to characterize it as a supplemental response when it's a discovery demand, and this is a discovery. The FOIA is not applicable at this point in time. This is the discovery rules, and so that's why I
Can we
requested-
fight about that in front of the judge rather than
Well,
ask a layperson their legal opinion on that? I'm trying to make it 100% clear what we did, so that there isn't any factual uncertainty that you need to clear up. And then I think it's a legal question for the judge, apparently, if you want to push it farther. And that's fine, but I don't know why we need to spend a lot of time questioning this witness who isn't even the FOIA coordinator about that. But it's your deposition, so to the extent you think I'm being obstructive, but I think you're mischaracterizing your question. You read it a certain way. I don't think that's the only interpretation of the question. I think there's another interpretation of the question which I've tried to explain to you to hopefully have you understand it. why it was answered the way that it was.
Well, at the time that this question was generated, there was no supplemental request, so it's not
At the
fair
time
to-
that it was answered, there was. We provided all of the documents at
You're
that
just
time.
being misleading, and I don't appreciate that.
No,
So let me,
that I can't let stand. That isn't the case at all. I'm trying to be as the exact opposite of that and trying to be completely transparent and telling you why the question was answered the way that it was.
but it is putting the burden on my client and her resources to have me go through that pile of papers when really the burden is on the public body claiming the exemption to
They're not
justify
claiming the exemption. They've produced the documents.
But they claimed the exemption the first time around.
But now they've tried to correct that problem. Here are all the documents. Isn't that what you wanted, were the documents?
Yeah.
You've got them.
So again, you can't answer how you, you can't give me an answer to which documents specifically were withheld from when you responded to the first request, right?
Correct.
Okay. Because you didn't engage in the proper inquiry that was required.
As I said, we followed our attorney's advice.
And your attorney's advice subjected you to this lawsuit.
Again, I'm going to make the same form and foundation objection. You keep using the words subjected you to this lawsuit. Again, it's just argumentative. There's two sides. Perhaps it was your attorney's advice that subjected you to it, or perhaps it was unreasonable behavior of the person bringing the lawsuit. I get that we're probably not going to agree to that, but why do you have to keep asking if it was your attorney's advice that subjected you to the
I
lawsuit?
thought we were talking about the FOIA. How could a request under the FOIA be unreasonable?
How could the plaintiff who filed a lawsuit not be the one who's subjecting them to the lawsuit? Of course she could. It would be a difference of opinion. You think that it was the attorney's advice that subjected them to the lawsuit. Perhaps the defendants think it was the behavior of the plaintiff that subjected them to the lawsuit. But why do we have to keep doing argumentative questions like that?
Are you instructing her not to answer the question?
There's not a question pending.
There was a question.
No, there wasn't.
Was it your? I mean, we could. I guess, like I said, you must be getting tired and you're getting argumentative. Was there a question? Do you believe that it was your attorney's bad advice that caused you to violate the Freedom of Information Act in regards to the first and second?
I have no opinion on that.
So you acknowledge that you violated the Freedom of Information Act with regards to your response to both the first and the second request, right?
What we're aware of at this time, yes.
And so you acknowledge that those were also violations back then, even though you just know now, right?
What we know now, yes.
Okay. And you're saying that the reason that you made those violations was because of the advice of your attorney.
And as our attorney has just stated, it's a matter of opinion.
Is it a matter of opinion whether or not you violated the Freedom of Information Act with regards to the response to the first FOIA
She
request?
just admitted that.
I know, so then
question
why?
ago.
That's what I'm saying. So is it really a matter of opinion? Because my understanding is you relied on your attorney's advice, right?
Correct.
And then you violated the Freedom of Information Act.
Yes.
Okay. Do you have anything else? I have no further questions.
I do have a couple questions for you, Janice.
Okay.
Is there a township budget for training?
Yes, there is.
Okay. And you had said earlier that training was expected and encouraged. Do you remember that?
Yes.
Are there sometimes, though, where somebody might want to go get training, but hey, the budget's been exhausted, and so, we'd love you to get training, but we can't afford it right now?
I'll
Correct.
object to the question as the form.
And is that true with other things as well? That sometimes, even if things might be good things, they're not budgeted for, and so they either have to be put off or have to be not done.
I'm going
Correct.
to object as the form again.
All right. In 2017, were there any other law enforcement proceedings other than the Marina investigation involving the township?
Just the criminal investigation that's ongoing with the prosecuting attorney and sheriff's department
Involving the treasurer?
involving the treasurer, yes.
I don't have any other questions. Thank you.
I do have a few questions based on your questions, I suppose. The criminal investigation, that was something that you requested to be initiated?
The board.
You asked the board, you said you would entertain the motion, so you were the one that suggested it to the board, right?
The board talked about it after we received the information from the forensic auditor and felt that we needed to move forward with it, or before we received the information from the forensic auditor, and we decided that we needed to move forward with that.
When did you talk about it?
I believe, to the best of my recollection, it was at the September or October board meeting, but I would have to look at our minutes to remember for sure.
Before you got the report from the forensic auditor, you talked about it, that's what you said?
There had been talk about it, yes.
And
I'd have to look at the minutes to know exactly when that motion was made. I don't remember what month it was made in.
and it was and then you made the motion despite. You said you'd entertain the motion despite the findings that Carl Heiser did not find
The
any
board had
criminality.
talked about it, and I, as supervisor and moderator of the meetings, always say I'll entertain a motion for, and someone makes a motion and we move forward with it.
So despite the fact that the forensic auditor found no evidence of any criminal wrongdoing, you thought it'd be prudent to persist in this criminal investigation, even though you have no evidence.
We still had issues
Objection
that we
form.
had questions and concerns about, so we felt we needed to move forward.
Isn't it true that this is just a punitive measure meant to sanction the treasurer for whatever wrong she had done, or whatever perceived wrong she had done during the marina fraud investigation?
No. I do not believe so, and that's my personal opinion. I can't speak for other board members.
So you had the information from your actual auditor, who said there was no criminal wrongdoing. Then you engaged a forensic auditor who said there was no criminal wrongdoing, and then you still wanted to persist in a criminal investigation, correct?
There was infractions when we had our audit from Gaybridge and Company that stated there were concerns of fraud or embezzlement, and that was stated in the, maybe the word embezzlement wasn't used, but there was definitely suspicion or possibility, and so we dealt with that. And the board decided as a whole to move forward with a forensic audit,
And you did that in a public session or a closed session, or?
public.
And are you communicating with other members of the board outside of public meetings?
Individually, but never in a quorum.
Right. So, but you communicate, and then do you share information? Do you ask for input from several different people outside of meetings?
No.
So you only talk to one at a time?
Usually I'll talk with one board member and maybe talk with another board member about another issue. But yes, we do communicate as a board, but never in violation of the Opens Meeting Act.
Well, at one point you would have persisted that you never violated the Freedom of Information Act too when this lawsuit was first initiated, right? You didn't know that you violated the Freedom of Information Act, did you?
Is this still redirect off of what my cross was?
It is.
Because it seems like we're getting pretty far afield.
Correct.
So you were wrong about your impressions of the Freedom of Information Act, right?
Under the advice of our attorney.
So you could be wrong
and
about about the Open Meetings Act too, right?
Everybody makes mistakes, you're correct.
And when the township makes mistakes, they make it at the expense of the taxpayer. Is that a yes?
Yes.
Okay, thank you. No further questions.
I don't have any other questions.
We are going off the record at the conclusion of the video deposition of Janice McCraner, and the time is 4:22 p.m.